The three members, Kennedy Agyapong, the MP for Asin Central, Henry Quartey, the MP for Ayawaso West, and Adwoa Safo, the MP for Dome-Kwabenya, were referred to the Privileges Committee for absenting themselves from Parliament beyond the permissible period without any reason. While Kennedy Agyapong and Henry Quartey appeared before the committee and attributed their absence to ill health, Adwoa Safo failed to honor the summons. She attributed her long absence from Parliament to family issues, saying, among other things, that her son was unwell. Prior to Parliament's recess in July 2022, the Majority Leader Osei Mensah Bonsu had, among other things, insisted that Privileges Committee's report should not be subject to debate in the House. This request was, however, rejected by the Speaker, who had indicated that he would give a detailed written report upon the House coming back from recess.
The old lady has given me an advice, and I think that advice is correct, because the issue raised by the Majority Leader is both of substantive and procedural law, and I need time to submit to this House.
The Speaker today, Wednesday, giving a formal communication on the matter on the floor of Parliament, dismissed attempts for the Speaker to declare some of the seats vacant without a formal debate of the Privileges Committee's report.
To imply any mandate into Article 97(1)(c) is one I am not prepared to do. Pursuant to Article 110 of the Constitution, my understanding is that where the Constitution does not provide a procedure, Parliament may regulate the procedure within that space as long as it does not offend the Constitution. It is in accordance with this power that Parliament captured the dictates of Article 71(c) in Order 16(1), which is to the effect that once a member is alleged to be in breach of the provision, his conduct is referred to the Committee of Privileges for inquiry. For the purpose of reiterating my humble view, once a referral has been made, therefore, the report of the committee does not complete the inquiry into the matter. The report of the Committee of Privileges, just like any other committee, is subject to the consideration of the House by way of a motion. Again, I am inspired and convinced this violation of the law by the provision of the Constitution, rules of procedure and practice of the United Kingdom, India, Canada, New Zealand, and Australia.
He cited instances that provide for a seat to be declared vacant in accordance to the law.
Article 97(1)(c) stipulates the conditions under which the seat of a member of Parliament may be vacant. Put differently, once the member has A, been absent from Parliament for 15 sittings of a meeting of Parliament, B, not obtained the permission of Mr. Speaker in writing to be absent, and C, cannot offer a reasonable explanation to the Parliamentary Committee on Privileges, the member automatically vacates the seat. This is the position that was endorsed in the case of Professor Stephen Kweku Asare versus the Attorney General and 3 others, unreported 2008 Court of Appeal. And I want to quote what they said. The plaintiff appellant, here is after referred to as the appellant, contends that once a member absents himself from Parliament without explanation for more than 15 sittings in this case, that member's seat automatically becomes vacant by operation of law. This argument is sound in law and I accept it, unquote. On the other hand, Order 161 of the Standing Orders provides: 1. The recommendations of a report of committee shall be presented to the House in the form of a report. 2. any time after the report has been presented to the House, a motion may be moved by the chairman of the committee for the acceptance of the report. Our orders specifically require that the recommendations of the committee must be subject to the consideration of the House, and that the plenary plays an important role in choosing to adopt or reject the recommendation.
In his ruling, Right Honourable Speaker Alban S.K. Bagbin said the preliminary objection for the admissibility of the report is hereby dismissed in limelight.
I have noted in this ruling, the decision as to whether or not to admit a motion is the exclusive preserve of the Speaker. In view of the foregoing, the House is well within its rights to receive and consider the report of the committee and make a determination arising out of the recommendations. In the circumstances, it is my ruling that the motion was rightfully admitted and the report of the committee is subject to the consideration of the House. It goes without saying that the preliminary objection of the majority leader to the admissibility of the motion for consideration of the report of the committee is hereby dismissed in limine.
However, Majority Leader vehemently disagreed with the ruling, adding that it is injurious to parliamentary business.
The Speaker, you have read your ruling, which I consider very...
Majority Leader.
The Speaker, yes, you will not listen to me. You will not listen to me. I've had the patience to listen to you. You must also listen to me. Mr. Speaker, you have made a ruling which I totally disagree with. I totally disagree with. I think it doesn't fit with the Constitution, and we must be able to comment
Honorable members.
I'm expressing my discomfort with this unfortunate ruling that you have made. I totally disagree. I think it doesn't sit with the Constitution and with your own earlier statements that we made in this House relating to this same thing. Very inconsistent. To that extent, Mr. Speaker, I'm serving notice. We know what to do. We come with a substantive motion to challenge your ruling, which I find very obsequious